If you have your clickers, I can't hear anything, so can they hear me? Isn't that testing? Is it better now? Testing, 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 testing. Oh, I can hear that. Okay. Whoa. Freaky. Okay. If you have your clickers, you can see if it works. Because I know, yesterday I talked to the clicker man, and he said that there was some concern. Some students didn't think their clickers were registering. And apparently, if you press it and you see a green light go on, that's a good sign. It's still going red. And you know what your device ID is, right? Don't you like have that tattoo now with that on it? This is all good. Yours still isn't working, Avi? Uh-oh, I saw a green light. What's it doing? Maybe you already voted. Yeah, see, that's good. You got green. Yeah. Green is good. Now, of course, we're secretly accessing your bank account every time you click, but it's only 50 cents a click. Are you clicking like over and over again? You shouldn't. Let's see. Still only 40. Did yours go green after you clicked it, Alma? But Alma, you don't have your name tag today. I don't know who you are. See, I remember your name, though. Pretty good, huh? All right. Well, at least some of you are clicking. Okay, so you click, and you see if the light was green, then you're good. Anybody not get a green light when they click? Anybody not get a green light when they click? No? Good? Okay. Okay, I'm gonna stop now, so stop clicking, because we should get to work. What we have to do today is we have to finish up the lecture on, hello? We have to finish up the lecture on declarant testifying exceptions. Okay. And let me, guys, hello, I'm teaching. Professor Lyon here. We were doing prior inconsistent statements, and identification. The three exceptions, it says non-hearsay in the rules, but we think of them as exceptions, where the declarant testifies. So the declarant is subject to cross-examination regarding the statement, and then there are additional requirements for each of these three. And what we had talked about was the prior consistent statement exception, and the case that, I guess it's pronounced Tomei, that's how everyone pronounces it, or Tome, but it's the Supreme Court case which held that prior consistent statement exception only applies to statements made pre-motive. But there were these unanswered questions, largely due to the fact that Justice Kennedy, in his majority opinion, didn't talk about the use of prior consistent statements as non-hearsay, rebuttal, or rehabilitation. An unfortunate lack of clarity, because then what it left open was these two questions, and I've already talked about these, so I'm just going to review these. The first one was whether prior consistent statements could be used to rebut other kinds of credibility attacks, and that is credibility attacks other than the ones that are mentioned in the rule, right? So the rule mentions basically allegations of some sort of evil motive or fabrication, right? Some sort of insincerity. But there are other ways that you could criticize somebody's testimony. You could suggest that they have a poor memory. A prior consistent statement would suggest that when their memory was better, they still believed it, so it would rehabilitate them. And the rule is silent as to the use of those statements. The rule says you can't use them for their truth, but can you use them as non-hearsay rehabilitation? And the answer is probably. Probably. They still are admissible to rehabilitate the witness, just not as substantive evidence. And the second question, which some people do think Tomei answered, but I think it's less clear. And this is whether a post-motive statement, again, although not fitting within the hearsay exception and therefore not admissible as substantive evidence, whether that post-motive hearsay statement could still be admitted as non-hearsay rehabilitation or rebuttal. And the answer to this is maybe. Now, the court at some point suggests that those statements are irrelevant, but as I quoted from Justice Kennedy, he said, well, there are situations in which a post-motive statement would be relevant and would rehabilitate credibility. And so to give you a more concrete case, it would be that day 1, day 20 example, right, with who killed the dog. And the person, after getting a bribe, might consistently and persistently continue to maintain what she's been bribed to say all the way up to trial. And the fact that she's saying it outside of a trial context, she's been bribed to say it at trial, the fact that she says it outside of a trial context has a little bit of oomph, right? A little bit of probative value, makes you believe it a little bit more. And that's all you need to say there's some rehabilitative value to her consistency. And you could still argue that even if the court says this is clearly inadmissible under 801 D1B, under the prior consistent statement exception, it's still potentially admissible as non-hearsay rehabilitation. Okay, so hopefully, I know that's hard, but hopefully it's hard, but you know, if you just barely understand it now, when you review closer to the exam, it will be even clearer. Because things do have a way of clarifying when you're under that pressure of understanding them for an exam. Okay, so here's my flow chart that allows you to apply the prior consistent statement. Okay? First question you ask is, was the witness's testimony attacked? And attacked at this point means attacked in any way. It doesn't have to be an attack on sincerity. It doesn't have to be an attack on memory. Any kind of attack. If the answer is no, then you're not even on the chart, right? You're out of there. The prior statement is not admissible. Prior consistent statement is not admissible. A prior consistent statement to be admissible has to in some way rebut an attack on the witness. If the answer is yes, you then have to consider what kind of attack, right? What kind of attack? And here the rule explicitly requires that the attack be on the basis of fabrication, influence, or some type of motive. And the way to think about this, although motive, as we'll see, can mean unconscious motives, generally speaking, the attack is one that goes at sincerity, that either the declarant has a motive to lie or someone had a motive to influence, right? So there's some evil, something undermining the process. And if that's true, then you're good to go. At least you're good to keep working the chart. If the answer is no, then you have to say, well, we have to ask a different question. Okay, we have to ask a different question. We have to ask, does the prior statement rebut the attack? Okay, so notice that what this means is we know it's an attack of some sort. If the answer is no, what kind of attack could it be? Well, it could be attack on your memories. It could be attack on your perceptions. And if the prior statement rebuts that attack, so for example, a prior statement would rebut an attack on your memory, right? You don't really remember what happened that day. I mean, that happened years ago. Isn't that right? Oh, yeah, I guess you're right. Or even if they say, no, you're not right. That's an attack on memory. Then you come back and you say, look, I've got a statement that the declarant made shortly after the crime occurred. Does that rebut an attack on memory? You bet it does. So now if the answer is, no, can't do anything. But if the answer is yes, see, I get more excited when the answer is yes. If the answer is yes, then may be admissible as rebuttal. And like I said, Supreme Court, they don't talk about this. Kennedy forgot, or one of his clerks neglected to tell him, or his clerks didn't understand evidence, which is probably the most likely possibility. This is not covered by the rule, but it is covered by the fact that you have a non-hearsay argument for rebutting attacks on memory and perception. Okay. If the answer is yes to this question, now you're going to ask a different question. Okay, so if the answer is they are attacking you, the declarant, on the basis of insincerity, then you ask this question. This is the real heart of Tomei. Then you say, well, was the statement that you're offering to rehabilitate. Was this statement made before this evil motive or the origins of the fabrication arose? So it would be the date at which someone bribed the witness, right? The date at which, in the case of, as you know, this is a child abuse case, the date at which the child learned that if she made this false allegation, she could get her stepfather out of the home, right? The day that something happened to make this person dishonest. If you have a statement saying, yes, the crime occurred from the declarant, and that statement was made before the declarant had a motive to lie, that's awesome. But if the answer is no, it still might have some probative value. It still might have some probative value. If the answer is yes, then it not only has probative value as rebuttal, but it's admissible as substantive evidence. Okay? Are there any questions about that? No? Does that mean you understand completely? Or you don't understand at all? It's either one or the extreme or the other. So I find charts work well. And actually, I can tell you an anecdote about that. I didn't use charts at all in law school. You know, the professors, they don't even bother really teaching where I went to law school. They just talk a lot, and then you get this exam, and you're like slammed with all this doctrine. And they've been talking about, this was the days of critical legal study, so they've been talking about post-structural, you know, crit reasoning all semester. But I started using charts when I took corporations, which was my least favorite class, and they worked like a charm. I did really well in corporations, hated the class, found the topic incredibly boring. The professor was terrible. Fortunately, he didn't even get tenure, right? He was that bad. It's kind of hard not to get tenure in law school. And the charts, man, the charts. And so ever since then, I've said, if you can systematize the reasoning that you use, and you can, don't let law professors tell you, oh no, it's too fuzzy. You can always systematize the reasoning. Then you're going to start getting better grades or pass the bar or whatever you want to do in life. In fact, when I sat down to propose to my wife, I had a little chart, right? Will you marry me? No. Well, don't give up. Will you continue dating me? Right? Because you can still admit it as non. So anyway. And here I am, 16 years of a very happy marriage. Well, 16 years of marriage, mostly very happy. Can we edit this part out of the tape? Now, here's what you call rebuttal use of evidence. You'll see the term bandied about, and it's annoying because sometimes it's called rehabilitative, sometimes it's called corroborative, and this is very misleading because corroborative really doesn't mean non-substantive. It really doesn't mean not admitted for the truth. It means admitted for the truth. It just means it wouldn't be sufficient on its own. But what I'm telling you is you'll see this language used. And when you see this language, you think, okay, what they mean is rehabilitative, right? What they mean is rebutting an attack on the witness. And what they mean is non-substantive use, right? So it doesn't have to fit under the hearsay exception to be admissible. Okay. All right, let's move to the next hearsay exception, identification. And I'm going to show you the rule, but you don't have to write anything right now. Okay? It's one of identification of a person made after perceiving the person. This is an overlooked exception. A lot of times people try really hard to get something in as a prior consistent or prior inconsistent statement, and they work through all the logic. You know, you spend a lot of time, and then they realize, oh my God, the witness was identifying the person who committed the crime. It's identification. It's admissible under this exception. And actually, that's the trick with hearsay exceptions generally, is you'll get hung up on a certain line of reasoning, and there will be an obvious, clear exception. And if there's an obvious, clear exception, you should not spend any time reasoning about close cases. That is a waste of your time. So identification, often overlooked. Make sure you think of it. Here's the steps. Of course, just like with these other declarant testifying exceptions, the declarant has to testify. The second is unique to this exception is the statement identification of a person made after perceiving the person. That's just the identification exception. All right? Is the declarant subject to cross-examination concerning the statement? That, again, is true of all three of these declarant testifying exceptions. And an example of this would be an example we used before when I taught you what is hearsay. But now we're talking hearsay exceptions, right? So Wendy testifies, I said, Al killed Bob. That is arguably a statement of identification of a person made after perceiving the person. Now, the fact that Bob was killed, you wouldn't be able to prove through this. But the fact that she saw Al kill Bob would be identification and would be admissible under 801D1C. Okay, that's awesome, right? That's awesome. Now, the assumption people make, though, is that the person who testifies has to be the declarant. Doesn't have to be. Notice there's nothing saying that this person, the declarant who testifies, has to be the person who testifies to that person's identification. So conceivably, and actually let me put this up on your slide, conceivably, can the statement be admitted through a witness other than the declarant? So for example, could officer testify that Wendy fingered Al? And the answer is yes. As you laughed at fingered? You guys are sick. Fingered means identified. Okay. Get your minds out of the gutter. Yes, as long as Wendy also testifies and can be cross-examined. Okay, so officer can testify that Wendy identified Al, and as long as Wendy testifies. So imagine what that means. Imagine what that means. That means that what if Wendy at trial says, no, Al didn't do it? Will you have to use the prior and consistent statement exception to get her identification of Al in, or can you potentially use this exception? Okay? Now I'm anticipating something on another slide, but think about that. Another question. Does the identification have to be made immediately or shortly after perceiving the person? You might think so, right? Because identifications aren't worth much if they're not immediately after. The rationale for the identification exception, which I neglected to mention before, is that identifications made pre-trial are more reliable than trial identifications, right? Even the law recognizes the obvious, that it's kind of silly when you go into court and they say, can you look around the room, and is there someone in the room who looks like the criminal? And, you know, the person has to look around the room and realize that the guy sitting next to the defense lawyer, that's the one I saw commit the crime, right? Now, I'm sure you've heard of these cases where the witness looks around the room and points at one of the jurors. That's happened. Or points at the prosecutor. And the prosecutor, of course, jumps up and says, no, I didn't do it, and runs out of the courtroom. Or points to the judge. So it can happen. But in-trial identifications are recognized as a silly little ritual. And for that reason, the identification exception comes into play. Well, then you might say, so it has to be a reliable identification. So imagine a scenario where the person, right before they go into trial, says to someone in the hallway, Al killed Bob, and then they get up on the stand. Can you admit the fact that right before they got into the courtroom, they said Al killed Bob? Does the identification have to be made immediately or prior? No. Wendy could have made the statement right before coming into the courtroom. Okay? So it's a very broad exception, as long as you can argue that it's identification as opposed to proof that the crime was committed. Is it necessary that Wendy saw the person identified? And this is just a little trick with what perception means. It doesn't have to be eyewitness. Wendy could be an ear witness, right? An ear witness. She could have recognized his voice. So it was Al who called me on the telephone. Would be admissible as identification. Okay? And last, this question I asked you to think about. Does the rule require the declarant to reassert this identification on the stand? Is there anything in the rule that requires Wendy to say, yes, that is the person who did it? No. So a lot of times you'll see a prior and consistent statement and you'll say, aha, well, it has to be made under oath at a proceeding. This won't come in. So maybe you could offer it as non-hearsay impeachment. And what you forget is that it might be admissible as identification, which doesn't require under oath, doesn't require it be at a proceeding, and doesn't care whether the witness is consistent or inconsistent at trial. The only thing that Wendy can do to shut down the exception is to refuse to answer any questions on cross. right? Because then she's not subject to cross-examination concerning the statement. And that is a precondition. But it's a very good exception, often overlooked. Okay. That, unless there are any questions about the identification exception, yeah. No, if she changes her mind, no, because the prosecutor can give the jury all sorts of reasons why she might have flipped, right? She might be afraid now, just the same reasons that we believe prior and consistent statements, you know, say in the case of the prostitute who was beaten up by her pimp, right? You could say, sure, she's scared now, but you can believe her identification because it was made so close in time and under different circumstances. So, it's totally different than impeachment. So impeachment, remember, is non-hearsay. It only cancels it out. This is admitted as substantive evidence, which means the jury can choose to totally believe the hearsay and totally disbelieve her flipping on the stand, right? You see that? And that's the same true if you got it in under the prior and consistent statement exception, right? And this is another exception, which means the jury can use this and ignore the trial testimony. Okay. Okay, is that clear to everybody now? Okay, good. So let's move to today's and at least 2 days, because we're going to talk about multiple hearsay, and multiple hearsay is hard. Sorry. Party opponent exceptions, though, are rather easy. So that will take us a couple days at least to cover. And you might say, who is this? Who is this? Have you done your reading? Yeah, it's a wolf. Very good. Got someone who majored in biology. It's a 10-month-old bitch wolf. I just love saying that. Bitch wolf. Sophie. It's Sophie the bitch wolf. Right? You remember? Which case? Are you guys doing your reading? You got to do your reading. Guess what? One of the exam questions says, what was on page 4 of Millant? No, not really. But you should do your reading because you'll understand stuff better. Millant. Millant is the case of Sophie, the 10-month-old bitch wolf. Okay. Here's what we'll do for today. Party's own statement. That's the first of the party opponent exceptions. Now, people often call this an admission, but you want to be careful because it sounds then a lot like admission against interest, which is a different exception with different requirements. The party's own statement is a very simple and easy to administer rule that it's just like the Miranda warning. Anything you say can be used against you, right? Anything your opponent has said is admissible against your opponent. Anything. Doesn't matter what it is. It's all going to be admissible. And we'll talk about how liberal the rule is. We'll talk about the Bruton case, which is one of the rare cases in which the Supreme Court has held that a limiting instruction doesn't work, there's potential prejudice, and therefore it limits the admissibility of admissions, but only in cases where you're jointly trying people and one person's statement could prejudice another person. So think about it as, you know, a bunch of defendants committing a crime together. That's where the Bruton problem comes up. And only in criminal cases, too, for the most part. There's an adoptive admissions exception, and this is, excuse me, boy, I hope that wasn't magnified too much. Adoptive admissions statements, my Coke talking. Adoptive admissions are when someone doesn't say something, but something is said in the presence of them, and they would normally object were it untrue. So this is where we'll talk about silence. Now, I can't remember how much more we talked about silence as hearsay, but we'll definitely talk about it today. So you understand where the objection of hearsay comes in and when the exception of adoptive admissions applies. And we'll talk about the situation with police questioning because, again, the Supreme Court has gotten involved. Because how you interpret silence varies, right? If you are sitting in a room and being interrogated by cops and they're accusing you all sorts of things and you're not responding, does that lead you to think that they're guilty? Or does that lead you to think that they're just exercising their rights? That ambiguity has led the court to say we've got to be careful about how much we allow prosecutors to make comments about the defendant's silence under conditions of police questioning. Speaking agents. Speaking agents are people who talk for you. That's going to be pretty straightforward. Agent employees. So this is where you offer a statement against your opponents based on what your opponent's agent or employee has said. And this is where we'll talk a lot about Millant, because Millant helps us to work this out, as well as actually the party's own statement exception. And then we'll talk about multiple hearsay. Now, you say, why are we talking about multiple hearsay? Well, because Millant not only teaches us a lot about admissions and about the liberality of the admissions doctrine, but it contains the multiple hearsay problem. And the multiple hearsay problem will initially appear very complicated to you, but it's not. It's a situation where the witness testifies that declarant said that some other declarant said. So it's where you get this, it's the telephone, right? The game that you play where one person says to another person, says to another person, says to another person. And every time you've got one person saying something to another person, you're adding a layer of hearsay, okay? And that's what multiple hearsay will deal with. There's a special rule for it. And then finally, we'll talk about the co-conspirator exception, which is also a party-opponent exception, because what you're doing is you're offering against your opponent a statement by one of the co-conspirators of your opponent. Okay? So that's what we'll try to cover. And as you can see, that's a lot of rules. It's 4 or 5 different rules with that multiple hearsay in the middle. And that's why it's going to take us a couple days to cover. And I don't think we're going to get to California v. Halley. We will talk a little bit about who decides the preconditions. And this gets us back into, you may have forgotten, but it gets us back into that 104A, 104B issue of whether the judge decides or whether the jury decides some conditions precedent to admissibility. Okay. But let me show you the rule and then tell you what to write. Statements, again, 801 uses this weird language which you want to ignore, statements which are not hearsay. What you want to think of is admissions are an exception to the hearsay rule. And if you want to avoid using language like exceptions or not hearsay altogether, you can say a statement is admissible as an admission and avoid that unhappy language. Admission by party opponent. The statement is offered against a party and is A, the party's own statement, in either an individual or a representative capacity. So what you want to write is offered against the party and the party said it. Okay. Now, you might say, well, there's some, my head is probably in the way. You might say, well, this is a little more complicated than that, because notice they say in either an individual or a representative capacity. And you might be thinking ahead to where we talk about agent employees. And you say, isn't that the agent employee exception? And no, the way to think about it is this. If you said it, it's admissible against you. And you can't get out of being responsible for it by saying, oh, I was just somebody's agent, or I was just someone's speaking agent. It's still admissible against you, right? So what's the name of that guy? The press secretary for Bush? Tony Snow. Fleischman, I was thinking that too, but you're as outdated as I am. Tony Snow, right? Really? Okay. It's okay. And I love that name, Tony Snow. I mean, what a great name for, it's a snow job, right? So Tony Snow says, hey, I was just speaking for Bush. Doesn't matter. Now, when we get to agent employee, right, and speaking agent, then we're going to want to offer it against the person you were speaking for. That's where we talk about agent employee and speaking agent. But here we're talking about you said it, held against you. Doesn't matter if you were speaking for someone else. Right? Sorry, Tony. What's the rationale? What's the rationale? Is the rationale that your opponent is a truth-telling person? Wow, do you really want to argue that? You can trust my opponent. He always speaks the truth. That can't be the rationale, right? And as you'll see, given the liberality of admissions, admissions doesn't abide by any kind of personal knowledge requirement. You can have opinions, speculations, all sorts of stuff that is totally unreliable. So reliability is not the basis for admissions. The basis for admissions, the reason why we say it's okay for anything your opponent said to admit it against him is that's the adversarial system, right? It's fair to do it. It's fair to do it. You're responsible for your statements, and you know what? Is there one thing you really can't complain about? Remember the problem with hearsay? You say, bring that declarant in, right? I need to ask him what he meant by that. And they're looking at you going, but you said it, right? So you really can't complain about a failure to cross-examine, okay? You can't complain. Now, you want to keep this rationale in mind, because when we get to statements by agent employees, you might start to say, wait a minute, now you really can complain. But the liberality of the admissions rule will still obtain, okay? It will still apply. And let me tell you how liberal it is. It's very liberal. Be careful. Like I said, when you hear the word admissions, you often think against interest. And actually, I mean, this happened to me as a young lawyer. I wanted to admit the mother's statements against her, and her attorney got really upset and said, but the statements weren't against interest. And what I was trying to admit was, right, most of the time, the statements you're admitting against your opponent will be against their interest, right? Why else would you want to admit them unless they're saying something that's going to hurt them? But this was a case where the mother had given excuses for her child's injuries that were so facially wrong, it incriminated her. But clearly it wasn't against her interest to say, oh, no, no, I didn't break her skull, she fell off the bed, right? So they weren't statements against her interest, but they were admissions because she said them, and the attorney actually thought they had to be against interest. And then, you know, it was one of these cases where, and people do this all the time in practice, they practice for 15 years and they've never cracked open the evidence code. So I showed her the evidence code. She said, wow, when did they adopt this? It's like 1640. Okay. Does the statement have to be reliable or trustworthy? And I've already told you this. No. In fact, you probably don't trust your opponent. Does the party have to have had personal knowledge? This will surprise you, right? Because is personal knowledge a potential objection to the reliability of any piece of hearsay? Well, we haven't talked about it very much, but the answer is yes, yes, yes. It is a legitimate exception, but in this case, it's not. And why? Why? Because reliability is not the basis for admissions doctrine. Okay. Now, some people push this too far, as you'll see in Millant, but that's the rule. Okay, here's Bruton, talked about in your textbook, but I'll summarize it for you, and it's actually pretty easy to understand. It's two guys tried jointly for postal robbery, right? Bruton and Evans. Evans doesn't take the stand, right? And you know this, even if you haven't learned this in class, you know this just from watching crime shows, right? You don't have to take the stand, you don't have to testify against yourself because you have a right against self-incrimination. And your right against self-incrimination in court is a testimonial right, right? You don't even have to testify. You might think about this. Do you think that's a good rule? You probably just assume, yeah, that's the right way to do things. But you know, most of the world doesn't believe in that rule. Most of the world says you should have to explain yourself, and you're the best person to ask. So get up there. You don't have to swear to tell the truth, but you should get up there and do it. United States of America, absolute right. But notice what his absolute right does to Mr. Bruton, poor Mr. Bruton. Evans confessed, and his confession is still admissible. As long as they obeyed the Miranda warnings, Evans' confession could be admitted. And Bruton objects, right? Bruton's like, hey, this isn't fair because he implicated me, and I can't cross-examine him, right? So it's the kind of hearsay that you shouldn't allow. And the judge says, oh, that's okay. We have a rule. Do you remember? A limiting instruction rule. I'll just tell the jury, you can use the confession against Mr. Evans, but just ignore the fact that he mentions Mr. Bruton. And we can trust juries, right, to obey limiting instructions. So what's the problem? Well, the problem is that it's so unrealistic to expect a jury to ignore such highly probative evidence as a confession that the court said, okay, we'll buy this fiction that juries can limit themselves and can understand this kind of limiting instruction, but we won't buy it here. And they held that the admission of the confession, even though the judge told the jury not to consider it, violated Mr. Bruton's confrontation rights. Okay? So there is a limit to how far admissions can go, at least in a multiple defendant situation. Now, what you want to think about is, so, okay, what's the obvious solution, right? What's the obvious solution? Well, they make it sound so easy. You try the defendants separately. And, you know, it's funny, when you're speaking, when you think about these issues in law school, or even as a professor, you say, oh, yeah, that's no problem. But then imagine how it is when you talk to a victim and say, well, yeah, we need you to come in and testify. And they go again, and you say, well, yeah, that was the prelim. And then you say, yeah, we need you to come in again. Again? Well, yeah, because 2 people attacked you, and we're trying them separately. So imagine, you know, how difficult that is. You have to put on the same case again. So prosecutors hate that. They hate that. Now, another possibility is you can redact the confession. What that means is that you can admit Evans' confession, but then the prosecutors would do stuff like, it would be, Evans would say, yeah, and then me and went to the store and picked out a gun, and then we went to the 7-Eleven and hit the shopkeeper, you know, hit the clerk on the head, and the jury's going, huh, who could that be? And they look over and they see sitting next to Evans, Mr. Bruton, right? And the jury, being very smart, says, I think is Mr. Bruton. And so the courts have been kind of hard on prosecutors who have tried to do that. And of course, the prosecutor, you know, is winking at the jury and pointing at Mr. Bruton as much as the law will allow. Does Bruton apply to civil cases? Well, that's why we all want to be civil practitioners. No, confrontation clause only applies to criminal, although there are due process rights. Even civil litigants have due process rights. And so some courts have extended it on due process grounds. And actually, that's a general issue that you want to consider. So when we talk about the hearsay confrontation clause issues, and then you say, well, it's not civil, you have to realize that the due process clause always allows you to make a confrontation clause-like argument. It's just not as strong. And is there any objection open to the co-defendant in a civil case, assuming due process isn't an issue? Is there any just evidentiary objection? And remember what you argue when you think a limiting instruction will not work? What do you argue when the jury is going to misuse the evidence? Yeah, 403, prejudice. Very good. You'll learn 403 if you don't learn anything else in this class. Okay. That's all I want to say about admissions. Okay, adoptive admissions. What are adoptive admissions? The statement is offered against a party and is a statement of which the party has manifested an adoption or belief in its truth. Now, I mentioned silence, but there's lots of ways you can endorse something without saying it. The rule is this, for your notes. It's offered against the party, and the party adopted it. So how can you adopt something? How can you adopt something? Well, one good way to adopt it, bless you, is to use it for your benefit, right? So say you requested insurance payments, and you submitted statements by witnesses. That's an adoptive admission. Now those statements are your statements. A police officer attaches witness statements in order to obtain a search warrant. Those are now the officer's statements. And we'll talk about admissions against government employees. It used to be you couldn't do that, but now you can, right? The only limit on adoptive admissions is that you do have to prove that the person knew the contents of what it was they were adopting. So if you blindly sign a document, right, it's unclear whether that could be an adoptive admission against you unless there was some evidence that you actually knew what the document contained. But I think there would be a presumption. You know, one of these presumptions we have is that you read what you sign. But boy, imagine how slow everything would become if you actually read everything that you sign. like when you go into the doctor's office. Actually, you probably could read it because they're going to make you wait an hour and a half anyway. But it's an assumption that we make that probably isn't true. So what is an adoptive admission? The easy case is, I asked the defendant, did you kill Bob? And he said yes. Right? That's the way you adopt something, is you acknowledge a question. Now, why, you say, well, that's just an admission. Why do you need it? Why do you need to call that an adoptive admission? It's something that the defendant said. What would be the problem? What would be the problem? What would be the problem? What is the admission here? If we were limited to the admission doctrine, what might a court do? What might they allow only? Well, what words were, yeah. Yes, they might just say yes. Now, how would you argue that? So let's say we didn't have adoptive admissions. So you say, I'm admitting this as an admission, Your Honor. And I say, well, I'm the judge, and that's the only admission here. This is hearsay. What would you say in response to me? Would you have a response? Is the witness quoting themselves hearsay, potentially? Witness quoting themselves is hearsay. But what would you say? There's actually an argument to get around this. Is that I asked the defendant, did you kill Bob, offered to prove the truth of the matter asserted? No. It's just offered to prove that it was said, effect on the listener, and this is the admission. So actually, you don't need adoptive admissions, but it helps, because judges who don't understand this whole non-hearsay argument might well limit you to the words of the defendant. So it's one of these cases where an exception to the hearsay rule solves potential miscomprehension of what is hearsay and what is not. Okay? So easy case, just you don't think about it too much. Someone asks you, you say yes, that's an adoptive admission. Harder case. Witness testified, I asked the defendant, did you kill Bob? And he said nothing. Right? Is that an adoptive admission? And why is that a harder case? Well, obviously, you know, if you say yes, you're saying yes. If you say nothing, what are you trying to say, right? Or are you trying to say anything at all? Or is the fact that you're saying nothing evidence that you didn't actually hear the question, right? So the question then becomes, when is silence an adoptive admission? And there's actually a really easy rule. Okay? And this is from the advisory committee, or wherever it's from. I think it's from the advisory committee. It might be from the textbook. Pretty sure advisory committee. But this is the rule. If the statement and situation is such that a party would probably object or dissent if he were not in agreement. And the way to put this in lay people's terms is, you wouldn't stay silent if it weren't so. So if someone accuses you of an outrageous crime, at least, and this may be a cultural thing, at least in our culture, the natural reaction is to violently reject the proposition if it's untrue, right? So if I say, didn't you rape your sister? Silence is pretty damning. You say, of course I didn't, right? It was consensual. No, you wouldn't say that. Of course I didn't. Sorry, that was bizarre. I guess I wanted to reemphasize this. So does that make sense? So you wouldn't say it if it wasn't so. Oh, and speaking of culture, a very helpful, I'm going to add this to my slides, a woman from Japan tells me that put your money where your mouth is. The expression in Japanese is, eyes speak more than words. Isn't that cool? Eyes speak more than words. Did I get that right? I don't remember who it was that told me. And then the Spanish expression is, dogs that bark do not bite. Isn't that cool? Now, it's not, his bark is worse than his bite. It's actually different. Like, dogs that bark do not bite. Okay. Just to help you, cross-culturally, so everyone understands. All right, when is silence legitimate evidence of guilt? And immediately, right, you're thinking, you have the right to remain silent. You have the right to remain silent. You have the right to remain silent, right? You probably can recite the Miranda Rules better than, most cops, because you've heard it so many times on TV. So defendant is arrested. He's given the Miranda warnings. You have the right to remain silent. But anything you say can and will be used against you in a court of law. Right? Do you understand these rights? And then you get to court, and the state wants to prove silence to prove guilt. He didn't explain himself to the cops. Come on. If you, and this is a commonsensical argument, if you were accused of a crime you didn't commit, would you just sit there dumb in the face of these accusations, these horrible accusations that the police are making? Right? No, of course you wouldn't. But the defendant says, wait a minute. You said I have the right to remain silent. And so the Supreme Court has said, pretty commonsensically, that it violates the right against self-incrimination, right? You don't have the right to remain silent if the state's going to be able to use your silence against you. So you are coerced to talking, and that coercion amounts to self-incrimination. Although actually now, I bet if the court decided, they could say, well, you know, you're not forced to self-incriminate, you're forced to explain yourself. And that doesn't have to be self-incriminatory. But that argument has never flown. Well, can the state use silence to impeach? Well, why is this different? Why is this different? Why is impeachment different? Well, notice that impeachment only happens if the defendant takes the stand. Okay? Why is that different? Well, let's think about it. First, the rule. The rule is easy. No, state can't use silence to impeach. And you're probably saying, well, because that violates the right against self-incrimination, right? And there's a hint here. The answer is no, it's not because it violates the right against self-incrimination. Why doesn't it violate the right against self-incrimination? And just stop and think about that. Why is using silence as impeachment different than using silence to prove guilt? And you're saying, well, it's non-hearsay. Okay. But why is it different in terms of self-incrimination? What do you not have a right to do as part of your self-incrimination right? Yeah. Yeah, you don't have a right to perjure yourself. And what impeachment is proving is that you've been lying on the stand. Exactly right, and that's exactly what the court says. So then, why does the court say that you can't use silence to impeach? If it's not a self-incrimination problem, what kind of problem is it? And as you probably can guess, remember, if it's not a confrontation problem, it's a due process problem. Ooh, and you can't hardly see that. But, right? There you go. Oh, it's right here. How did it end up down there? See? Can you see it on my back now? It's kind of cool, actually. My brother made a joke about that. There's a kid in high school who was so big, they used to show movies on his shirt. Yeah, kind of mean, huh? Guy later killed himself. Due process irrelevance. It's a violation of your due process rights. Nervous laughter. Sorry, dark mood today. Dark mood. I don't know what's the matter. Blame it on the cold or the Coke or something. It's irrelevant, and it's a violation of your due process rights, and also, of course, Alma, 403. Yeah, Alma will be our 403 person. When I point to you, you just shout out, 403! You'll say, oh, that's Alma. She's the 403 lady. Okay. Now, does someone else want to be the 401 person? Alex, you want to be the 401 guy? Okay, good. And I don't mean Stephen Colbert's. Doesn't he have Formula 401? Isn't that what he calls his man juice? Do you watch Stephen Colbert? You guys don't stay up late enough to watch it? All right. Never mind. Defendant hasn't been arrested. This is really interesting. This is really interesting because here's what happens when the court is very liberal and then Nixon comes in. You know how you know the history of the Supreme Court. It's really amusing. The court reached the zenith of liberality in 1968. And then, of course, as Jules Wickover says, that was the year the dream died. Right? Martin Luther King gets killed. Bobby Kennedy gets killed. Nixon is elected president. Escalation of the Vietnam War, massive infusion of conservatives into the government, and Nixon starts adding conservatives to the court. 68, it looked like they might have all sorts of due process rights, immediately starts to be stripped away. So post-68, the court starts hearing these cases where defendants are saying, my due process rights were denied, right? And the court says, well, no. if you haven't been arrested, and this was a moot court topic a few years ago here, if you haven't been arrested, notice that they haven't given you your Miranda warnings. And if they haven't given you your Miranda warnings, you haven't been told you have a right to remain silent. And if you haven't been told you have a right to remain silent, no problem. If you haven't been arrested, they can use your silence for impeachment, and it's unclear what the rule is. The court hasn't definitively said, but they may be able to use it substantively. And of course, the difference is, even if you don't testify, if it can be used substantively, the prosecutor can point out the fact that you didn't come forward to report the crime before you were arrested. Not a Miranda violation, not a due process violation. Well, then the natural, and this was like a law school hypothetical for many years, and then finally this came up to the court, and they said, well, what if this happens? What if the defendant has been arrested, but the police forget to give him the Miranda warnings? Or actually what the police do strategically now is they let him sit in the car. You let the guy sit in the squad car. And you know what it's like? Well, I don't, but I can imagine what it's like when you're sitting in the squad car and the police are just kind of, they've got all day. And you're thinking, oh my God, I might go to jail. I'm in a lot of trouble. I got to say something. Maybe I can talk my way out of it, right? You're waiving your rights right there as you sit in the back of the car. And since they haven't given you the Miranda warnings and they haven't told you have a right to remain silent, then, right, silence is meaningful. Silence is meaningful. And it seems crazy, but the court has said impeachment is okay, and it may even be okay for substantive purposes. And why is that crazy? Why is that crazy? Because you know from watching TV that you have a right to remain silent when arrested, right? So it doesn't take the cops to tell you what your rights are. And so to the extent that your silence in the face of Miranda warnings is ambiguous, right? It could be just you exercising your rights. It shouldn't matter if the police have told you those rights or not. You still know that, and your silence is still ambiguous. And so the court could have easily said it's just as objectionable to offer your silence post-arrest, pre-Miranda warnings, as it is to offer your silence post-arrest, post-Miranda warnings. But the court didn't do that. And the court said basically, unless the state, not some TV show, has told you you have a right to remain silent, your silence is potentially good evidence against you, and you don't have a confrontation, you don't have a Sixth Amendment or a due process right to have it excluded. Okay? So the rules are actually quite easy to learn. They just don't make much sense. All right. Are there any questions about silence? Great. Let's talk about speaking agents. This is exception number 3. Statement is offered against a party and is a statement by a person authorized by the party to make a statement concerning the subject. This is actually a very easy exception to understand, and the way you can write it is this: offered against the party and a statement by a person authorized to speak for a party. Right? And examples of speaking agents, right? Who is a speaking agent? Well, Tony Snow. But before we get to Tony, a board of directors speaks for the corporation. This is something Malat would teach you. Attorneys speak for their clients, hopefully. Brokers, press secretaries, Tony Snow. Okay? So you know what a speaking agent is. A speaking agent is a special kind of employee. Maybe not even an employee, maybe they're an independent contractor in some sense. But there's someone who you say, you speak for me, you are my mouthpiece, and since they speak for you, their statements can be held against you. Okay? That's easy. All right. Last that we'll do before our break, but not the last party opponent exception, that will be conspirator statements, is agent employees. Again, pretty straightforward. Statement is offered against a party and is a statement by the party's agent or servant concerning a matter within the scope of the agency or employment made during the existence of the relationship. Okay? And here's what you want to write, is It's offered against the party and is a statement by an employee. Now notice that employee is not the word they use. They say agent or servant, but it's the commonsensical definition of agent or servant. It's made while employed, and it's concerning a matter within the scope of employment. Okay? So this is the pendency requirement, and this is the scope requirement. But anyway, notice that it's about your job while you're employed. And so, you know, the easy hypothetical, and actually I think this is one of my multiple choice questions, so you'll get this one right, is the guy is in a car accident, and he gets out of his car, and he turns to his chauffeur, and he says, "You're fired." And then the chauffeur turns to someone else and says, "It was all my fault." Is that a statement made by an agent employee under the agent employee exception? No, because he wasn't while he was employed. So notice the statement has to be made while employed. Okay, so that's an easy one. Little harder one is government employees. Remember I mentioned the officer who you want to admit against not the officer but against the government. And is the officer an employee of the government? And older cases said, well, you know, the problem is so many people work for the government, it would be unfair to allow these in as statements by agent employee. Nowadays, they don't make that blanket a statement. They often do allow statements made by government employees against the government. But the issue will be personal knowledge in this sense, whether the matter is within the scope of employment. So you have to, if you're the government, you try to narrowly draw what the person has true responsibility over, and if they have no responsibility over something, then you argue it's not within their scope of employment. Okay. Okay. Now, next we're going to do Millant, which will be a review of these exceptions. We'll get into the topic of what multiple hearsay is, and then we'll do co-conspirators. So I think we'll spend at least the rest of today on Millant. Okay, and it's, let's see what time it is, and then you know when to come back. So let's take a break and come back at about 10 minutes. So this says 11:37, so that says 11:40, so about 11:47.
Professor, I didn't get that one comment about because you're not allowed to perjure yourself.
And we're going to start talking about the Millant case. Okay. Chop, chop. Please return to your seats. Alma? Yes, all right. Okay. All you no credit students, please return to your seats. I can tell the stragglers. They have this relaxed look, this swagger. Oh yeah, I'm a credit, no credit. And then, and if you notice this, have you taken lots of credit, no credit? And then you start to get scared because now instead of a whole range of possible grades, failure or passing. And all of a sudden it's like, oh wow, there's a 50% chance I might fail. It's seriously, and I've had students come in and they say, you know, I've never studied harder for an exam. And I'm like, are you credit, no credit? Yeah, because I'm worried you're going to fail me. And I always assure them, I say, look, I only fail one person every semester. It's just one, right? It's like Russian roulette, just one chance, so don't worry about it. I think it's the student who just visited me 5 minutes ago. Okay, so no, actually I don't fail one. It's closer to 25. No, it's don't worry about it. Although you do want to pass the bar. Okay, was Daniel Millant, 3-year-old, bitten by Sophie, the 11-month-old, although with jaws of steel, okay, the bitch wolf. And this actually is from the Wild Canid Research Center website. So this may well be Sophie. And you know what that is, right? No, it's not the grade distribution. What is that? Oh! A cry for help? Or I'm about to eat this child. That was the issue in the Millant case. The plaintiffs are Daniel's parents. The defendants are Wild Canid Survival and Research Center. Not exactly the deep pocket you'd hope to sue, but pretty close. They can dip into their foundation funds to pay you off. And Kenneth Poos, or Poos, let's call him Poos so we don't get those, naughty jokes. Kenneth Poos, Director of Education for Wild Canid. And Kenneth Poos, man, this guy, I would fire him in a minute if he did what he did in this case. And I would fire the entire board of directors because they have no idea what the hell they're doing when they write this stuff in their minutes. And if you ever work for anybody like this, you give them some good legal advice because you'll see they totally hurt themselves by these statements they make without any personal knowledge. The problem is nobody had personal knowledge. The court acknowledges this. Nobody saw or knew how Daniel was injured. Now, you know what happened, right? This is really part of the reason why I love this case is it's just so interesting. You have a 3-year-old boy, and his mom says, do you want to go over to your friend's house? I think it was his friend or it was a cousin or something. And he's 3. And do you know how little a 3-year-old is? You guys probably don't. But I could sit him up on the chair and he'd be like this big. So a little tiny 3-year-old. And nowadays, would you even send a 3-year-old out in the front yard? No. But back in those days, 3-year-old goes across the street, walking down the block, and he passes by the Poos' house. And what do the Poos have in their backyard? But an 11-month-old wild wolf, right, with massive jaws of steel, right, this bitch wolf who's built to kill. And little 3-year-old, apparently, he goes up to the fence and he says, hi, doggy, right, sticks his hand in. But we don't know for sure what happened because the scratch marks on the boy were not consistent with wolf's scratch marks. They were consistent with going under the fence. Well, maybe the wolf dragged him under the fence, but maybe little Danny wanted to play with a nice doggy. He scoots under the fence, and at the point that the neighbor sees him, Sophie has her face right above the little boy. He's crying, and Sophie is making this noise, the noise I tried to recreate little bit ago. And the issue is, what was that noise? And a wolf expert testifies for the defense. And here's where the hearsay of dogs comes in, right? Was this hearsay to quote what Sophie said? No. The wolf expert said the wail was a sign of compassion, not attack. So the defense's argument is little Danny pushes himself under the fence, scratches his face, starts to cry, and the wolf is not going to kill him, but is asking for help. Well, after this happens, and the mother, of course, turns away just at the moment when she could testify what exactly happened. She hears the screams. The neighbor hears the screams. The neighbor is the one who sees Sophie near Daniel's face. Clark Poos hears the screams, right? He's Mr. Poos's son. He rescues Daniel, right? And he goes to find Mrs. Millant. So Clark goes out into the backyard where the wolf is chained up. And here's what's interesting, too, is when he gets to Mrs. Millant with little Danny, Mrs. Millant testified that he said, a wolf got Danny and he is dying. Right? Yeah, right. Did Clark say that? He denied it. But one thing you want to ask is, well, wait a minute, that's hearsay. And we don't know the exception for that yet. So we'll come back when we find the exception for that statement. Is he an agent or employee of Wild Canid Research Center? Are you an agent or employee of your dad? No, fortunately not. Mr. Poos comes home. Talk to everyone present. Well, he's investigating, so theoretically he obtains some personal knowledge. But does Clark know what happened? No. Does Mrs. Millant know what happened? No. What about little Danny? Little 3-year-old Danny. That's unclear. It's never stated in the case whether Danny made any statements or is capable of making any statements. Although that might be the reason why the court is inclined to trust Mr. Poos. Is what they're really trusting is the words of a 3-year-old. But the court never discusses that. The trial court quite reasonably said, you know, this stuff nobody knows, so this stuff is all speculative. Only they did it on the basis of hearsay. So the trial court says, I'm not going to admit anything that points towards the dog, or rather the wolf, Sophie, as having bitten the child. I'm not going to admit any of this stuff. And that included really crucial pieces of evidence for the plaintiff in order to get past a directed verdict. So Mr. Poos talks to everyone. He goes to the office where Mr. Sexton, his boss, works, and he writes a note. Sophie bit a child that came in our backyard. Now, imagine, you know, the situation where you're in a hurry, you're trying to find Mr. Sexton, it's really stressful, you've got to talk to him right away. You know, are you going to take the time to go into a long report of why you think this? No, you're just going to write something. And actually, it's as quick as this. Owen, would you call me at home? Sophie bit a child that came in our backyard, all has been taken care of. I need to convey what happened to you. That's the entire note. And the trial court said, no, it's hearsay. Mr. Poos then sees Mr. Sexton later that day, and he says, Sophie bit a child today. Okay? So, second statement. That's a personal statement, not a written statement. But as you know, hearsay doesn't care. Written, spoken. And finally, the last piece of evidence was the minutes of the director's meeting refer to, quote unquote, the incident of Sophie biting the child. In fact, the exact quote is, there was a great deal of discussion about the legal aspects of the incident of Sophie biting the child. And here's where Fire, the lawyer, comes in. Apparently, there was no discussion of the legal implications of saying Sophie bit the child, right? So if you're a lawyer, do you tell the board of directors to put in, you know, our wolf bit a child today? No. First piece of advice, don't say anything about that. Say allegedly, reportedly, purportedly, or don't say it at all, but they screwed up. All right, so those are the three pieces of evidence. Now, Wild Canid's doing pretty well because the trial judge says this is all hearsay. You know, none of these people really know what happened, so it's out, and plaintiff loses. But the appeals court, the Eighth Circuit, says, wait a minute, you're not reading the party opponent exceptions correctly, okay? So first of all, are these two pieces of evidence admissible against Mr. Poos? And the exception that applies, that is easy and you should never forget, is if you're offering a statement against Mr. Poos and you're suing Mr. Poos, anything Mr. Poos says is admissible as an admission. Eighth Circuit says, what are you guys doing? This is so clearly, to the trial court, what are you doing? This is clearly an admission by a party opponent, clearly admissible. Okay? Shouldn't even have to argue about this. Well, what about these statements offered against Wild Canid? Because remember, you have two different defendants. Are these statements admissible against Wild Canid? Is Mr. Poos a speaking agent for Wild Canid? Is there any evidence that they authorized him to speak? No. He's not a spokesman. Although I guess you could say, you know why the wolf was chained up in his backyard? Because he would go around to schools, elementary schools, and introduce Sophie, and Sophie was chosen because she was such a gentle wolf that she could be trusted with young children. Right? And so he had chained her up in the backyard because it was part of his job to go around and teaching children that wolves are actually very, very sweet and gentle creatures. I'm not sure they should be teaching kids that, because not all wolves are as nice as Sophie. But anyway, clearly he's an agent, employee. Clearly this falls under 801D2D, because he's an employee of Wild Canid. Now, there's a really good question over break, and actually I wasn't sure what the answer was. So the student says to me, well, wait a minute. Doesn't this make the speaking agent test redundant? Because anytime you're an agent, your statements are admissible, and a speaking agent is a kind of agent. So why do we have the speaking agent exception? And actually, I did think of an answer. When they use the term agent here, they're thinking more in terms of a full agent, an agent under the common law definition, which is someone who can really act on your behalf, who can make decisions on your behalf. And a speaking agent doesn't have to have that formal a relationship. They just have to be authorized to speak for you. So a spouse could be a speaking agent, right? Even if they don't have all the full powers of an agent. And so the two exceptions are actually distinct. But here, he's clearly an agent. He's clearly an employee. And the only issues are then, is he an employee of Wild Canid? Yes, he's the director of research. Was the statement made while he was employed? Yes. Maybe not for long, but they hadn't fired him yet. And this is the only thing that has any possible interest for someone trying to, turn this into a hypo for an exam or something. Was it concerning a matter within the scope of his employment? And you have to say, why did he have Sophie chained up in the backyard? If he had absconded with Sophie, right, if he was running away with Sophie, maybe not. But she was in his custody as part of his job. And so there's no question but that the prerequisites for the agent-employee exception are fulfilled. Right? What is this trial court doing? How could it ignore these obvious exceptions? And that's what the Eighth Circuit is saying at this point, is you totally screwed up, trial court. So now you've got double screw-ups, right? Mr. Poos screwed up, the board screwed up, and now the trial court is screwing up. This is the last piece of evidence. We haven't discussed this piece of evidence. The minutes of the director's meeting referring to the incident of Sophie biting the child. It requires separate treatment, because notice that the declarant is different, right? The declarant up to now has been Mr. Poos. Mr. Poos wrote the letter. Mr. Poos made the statement to his boss. But now, who is the declarant? And actually, you can think about this, right? Who is the declarant? Is the declarant the person who took the notes? Or is the declarant the board of directors? You're only allowed to say 403 now. Sorry. No. Which one do you think? Board of directors. Although you can argue that there's that person who's typing it, right? Maybe even interpreting it. But if you did think that hard about it, what relationship would they have to Wild Canid? Yeah, they would be a speaking agent, right? A writing agent, a speaking agent. So either way, if you think about it technically and say, well, it's the person who typed the comments up, but I think most courts would just cut to the chase and say, look, it's the director speaking through this document, and what exception allows the board of directors statement to be used against Wild Canid? The board of directors is what? What are they? Are they employed by Wild Canid? It's easiest to think of them as either speaking agents or as agents, okay? And that's what the court decides. The court says they're speaking agents. The board of directors have the right to speak for Wild Canid. And so it's clearly admissible against Wild Canid. Now, the only tricky thing here is this one, are their statements admissible against Mr. Poos? And here's where you realize that the agent-employee exception is not bidirectional, right? The agent can bind the, what is the relationship? Agent to principal. Thank you. I couldn't remember that. I know debtor and deadee. So agent to principal. So the agent can bind the principal. Are the principal statements admissible against the agent? The employee can bind the employer. Are the employer statements admissible against the employee? Does the agent-employee exception run both ways? Should I have used your clickers? 80% of you said you enjoyed using your clickers, but only 54% said it helped you to learn, which means 26% of you enjoy not learning. I was a math person, so that's how I could do that so quickly. So what's the answer? Can the agent bind the employee? Does the agent-employee exception run both ways? That's all I need. Thank you for your negation. No. There was no servant or agency relationship which justified admitting the evidence against Mr. Poos. Now that sounds like they're saying Mr. Poos is not an agent of the board or a servant of the board. But they're not, that's not what they're saying. They're saying the exception doesn't run from the board to Mr. Poos. So Mr. Poos's one happy day is that this piece of evidence is not admissible, but these other two pieces are just as damning, if not more damning. Okay. Well, why does the trial court ignore these clear exceptions to the hearsay rule? And the reason the trial court did it is the trial court wasn't a literal reader of the rules. The trial court thought about the rationale for the rules. And I want you to think about that. What seems unfair? What's screwy about admitting Mr. Poos's and the board's statements, particularly against Wild Canid? Because remember, what's fair is you said it, you can explain it. Why is it not fair to admit these statements? And there are two reasons, at least. But what's the big reason? What's the reason why you don't trust this hearsay? Yeah. Yeah, because there's no personal knowledge. It's unreliable. And why is it particularly unfair to offer Mr. Poos's statements against Wild Canid? Remember, the rationale is you said it, you can explain it. But can Wild Canid explain why Mr. Poos said this crazy thing? Not really. Not really. So the main problem is that Poos and the board have no personal knowledge of whether Sophie bit Daniel, sorry. And this is where, and you may not see the connection, but you will in a moment, this is where multiple hearsay comes in. Okay? And now we have to slow down because the reasoning gets a little bit weird. And I should tell you, if you want the best trial clerkship experience, you want to, and I mean everybody in the world, well, everyone in the United States wants to work for Judge Weinstein. Southern District of New York, awesome district to work in. Weinstein, amazingly brilliant district court. So you're doing trial work. He understands evidence. He actually has written a treatise about evidence that is really good. And the Eighth Circuit has to deal with Mr. Judge Weinstein. And it's, you know, this kind of respect, when you had the Eighth Circuit, they could just say, he's just a district court judge. That's how they could do it. They could just pull rank. But he's smart enough, and he's clear enough that they have to deal with this argument. And here's his argument. Although an express requirement of personal knowledge on the part of the declarant of the facts underlying his statement is not written into the rule, it should be. He feels that is mandated by Rules 805 and thanks, Alma. 403. You get tired of this. I know. I did. You're so compliant. All right. Well, you know what 403 is, right? 403 is prejudice, whether the jury will give evidence too much weight. Now, what's your name? Stephen, you gotta get that card in, because I'll learn your name if I see it a few more times. Stephen, can you explain this? You understood why this personal knowledge is a serious problem. How do you turn that into a prejudice argument? Or can you? Yeah. Well, imagine the jury hears something, and it's lacking foundation. How does that become a 403 problem? Am I giving you a good hint or a bad hint? How is this a 403 problem? You let the jury hear something that has no foundation. It's a 403 problem because, well, he's not arguing relevance, so it's got some little relevance, right? Maybe he heard it from Daniel. Maybe it does have some reliability, but, Joel? Okay. And the way you want to say it is, so even if there's some probative value, because it might mean something, the jury is going to assume it means a lot more than that. Yeah. So that's the prejudice argument. So it's based on the lack of personal knowledge, but it's saying the jury won't understand how seriously deficient this piece of hearsay is. Well, what is 805? What is 805? And I'm sure that all of you, when you were reading this case, had your little book next to you. Yeah? And you flipped through and you looked up 805. You really should. You really should. Because, well, you'll remember it better. But I'll tell you what 805 is. 805 is hearsay within hearsay. And here's 805. Here's the rule. Hearsay included within hearsay is not excluded under the hearsay rule if each part of the combined statements conforms with an exception to the hearsay rule provided in these rules. This is when I meditate, I think about 805, right? Because notice how many times they say hearsay. Hearsay included within hearsay is not excluded under the hearsay. And how many times do they say rules? Under the hearsay rule, if each part conforms with an exception to the hearsay rule provided in these rules. What could be clearer than that? And the way you want to write this in your notes is multiple hearsay is okay if each layer fits within an exception. And notice I'm using totally different language, but I think it's easier. Multiple hearsay, what is that? Well, that's hearsay within hearsay. But as you'll quickly find out is there is hearsay within hearsay within hearsay within hearsay within hearsay, right? And you can say that easily and quickly by just saying this, multiple hearsay. Might be double hearsay, or triple hearsay, quadruple hearsay, or quintuple hearsay, or septuple hearsay, or octuple hearsay, or nonuple hearsay. Or it could be zenuple hearsay, or even 11uple hearsay. I'm not sure about 11uple. I'll have to check my math dictionary. It's okay if each layer fits within an exception. So you have layers of hearsay, right? Like peeling an onion. Okay, this is hard. But I'll give you an easy example. Remember our famous Wendy? So single hearsay is Wendy testifies, Deborah said, Al killed Bob. Okay? So absorb that. And I say to you, who's the out-of-court declarant? Say it. Who's the out-of-court declarant? Deborah. It's not Al. It's not Wendy. Okay, you got to make sure you understand that. Double hearsay. Here's an example of double hearsay, a form of multiple hearsay. Jill testifies. Wendy said, Deborah told me Al killed Bob. Whoa, that's a warning sign that you've got some multiple hearsay going on, folks. All right? See that right there? Oh, and let me ask you this. So in other languages, do all languages have quotation marks? So like in Japanese, do they have a notation for a quotation, or does it say he said that? Yeah. Uh-huh. Okay. Chinese, anybody? Yeah, that's Japanese, I know. All right. Well, anyway, because this is an easy sign in English, you can say, hey, look at those multiple quote marks. Who's the declarant? Who's the out-of-court declarant? Is it Jill? No, she's the witness. Is it Wendy? Uh-huh. Is it still Deborah? Yeah. We have two out-of-court declarants. Now, that seems really easy. You say, oh, I just looked for more than one out-of-court declarant and I got multiple hearsay. And that's not. It has to be layered. So let me show you that that is too easy. Multiple declarants does not always mean multiple hearsay. All right. This is multiple hearsay, the one we just did. Jill testifies, Wendy said, Deborah told me Al killed Bob. Quote, 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 quote. This is not double hearsay. Jill testifies, Wendy said Al killed Bob, and Jill says, Deborah said Al killed Bob. You see the difference? Do you see the difference? What's the difference? What is double hearsay? What is declarant Deborah doing here that declarant Deborah does not do here? Yeah. Yeah. Okay. And another way of asking it is, so what is Wendy doing here that Wendy is not doing here? Because I asked about Deborah just now, and you were correct. And now think about this declarant. What is this declarant doing here that Wendy is not doing here? Wendy is saying something directly here, but here Wendy is quoting, right? And quoting adds another layer of hearsay. So it's only multiple hearsay if one declarant is quoting another declarant. It's that easy. The declarant quotes. That's hearsay. The declarant quotes. We have just a few minutes, so I'm going to go over this all over again. What's today? Wednesday? Next Monday. Oh, Tuesday. Oh, no, we don't have the Monday, Tuesday thing. We just don't have class. We do it Tuesday. Okay, we have a special Monday is Tuesday class. All right. Well, that would be a great day to discuss multiple hearsay, because you'll be confused enough by that Monday, Tuesday thing. So let me just say a little bit more, and then we'll take our break. I mean, we'll take our week. Single hearsay. Witness testifies, declarant said, matter asserted. Okay? Double hearsay, witness testifies, declarant 1 said, that declarant 2 said, matter asserted. Okay? And here's where you get into layers. Layers. This will be called the outer layer. This would be Wendy in our example. And this we'll call the inner layer. And the rule is going to be simple. How can you admit double hearsay? How can you admit double hearsay? What you have to do is you have to fit both of these statements within a hearsay exception. Not the same hearsay exception necessarily, they can be different, but both have to fit within hearsay exceptions. Okay? Now, you're asking a lot of questions right now. You're saying, what? And you're saying, what about documents, maybe? And you're saying, what does this have to do with Millant? And we'll answer all those questions next Tuesday. Okay, so I'll see you next week.